Hi, I have an appointment at 9 with Frida.
All right, your name?
Greg Carringer.
Greg?
Yep.
I'll let her know.
Good.
Will do. Thank you. So you can go down here now. You want to back over to the elevator?
Okay.
Down one, the 16th floor, and off the right.
Off to the right. Okay. Okay. Okay, good. To the right.
Hi, you're
Greg.
Greg, Frida Richard. Nice
Hi,
to meet you.
thank you.
Come on in.
Okay.
Have a seat there.
Okay.
How are you doing today?
Okay.
Good. Well, hopefully, considering the smoky air here, it's
Right.
quite thick. It's amazing you can actually taste the smoke.
Yeah, you can.
Yeah, it's
And,
really bad.
you can smell it even with your windows closed.
Oh,
Well, I don't know.
oh,
Probably
yes.
you don't hear, but at home I do.
Okay.
So I don't
Well,
know
I
if you can
noticed in
smell
the
it.
parkade in the tower is like two levels been underground. It's probably actually.
Yeah.
Well, it gets everywhere, right in the vents. Okay, so Greg, my name is Frida Richard. I'm one of the
Right.
trustees here at Grand Thornton. I think you've had maybe an initial discussion or email back and forth with Teresa Steves.
Yeah, that's right.
Okay, so the purpose of today is simply to talk about the options available. And she did forward to me the workbook you completed, and I just printed off.
Right.
Haven't had a chance to review them because that came in yesterday afternoon. It looks like you sent in your 2018 tax assessment,
That's right.
and it's showing it's a refund. I'm assuming you've received that refund.
That's right. Yes, I have.
Okay.
Yep.
Okay, and then the other attachment, let's see here, that was Scotia.
Yeah, that's just my bank account.
Okay. So is it currently it looks like it's in an overdraft
That's right.
position, if that's fairly current, okay.
Yes.
Then you've got the RSP and then the Visa accounts. Okay, got it.
Right.
All right. So I'm just going to grab a folder here.
Okay.
That's good. Okay. So in sort of discussing how to, ways to tackle this, but by the time people get to us, we've no doubt that, they consider things like debt consolidation, consolidation loans to their bank, selling off assets if there are any fairly liquid assets to try to put towards the debt, and then negotiating with the creditors, okay? And so what's your key concern? Usually, either people are handling their debts by paying minimum payments, and they're quite happy with that, or something has happened, an event, a circumstance that sort of propels people to think, I'm in trouble here, I need to do something. So what is it that's been a key concern for you?
Well, the key concern was that I had a lawsuit
Okay.
against 13 defendants, and the defendants filed applications for summary judgment, and so that's
his total $92,000 approximately.
Yes.
And you're saying that comes from 4 different law firms.
Right.
And so I'm assuming they're representing 4 different plaintiffs.
Well, they're representing 13.
Oh, 13.
Yeah.
Okay.
Yep. So one law firm represents just the chief of police.
Okay.
And so, just on that specific note, so they sent the lawyer for the chief of police.
Yeah, which lawyer was that?
So that was Jeremy Taylor at Field Law.
Field, okay. So I'm just going to make a note. I'm going to break down the information here. So,
right. Yeah, because it's pretty complicated.
Sure. Yeah. Okay. So Field Law represented Chief of Police?
That's right.
Edmonton Police, I'm
That's
assuming,
right.
right?
Yeah, and he's retired now. So he retired on October
this
31st.
was the previous,
That's right, exactly. Rod Connect.
Right, thanks, yeah.
So he retired on October 31st
Okay.
of last year. So so I mean, it's kind of strange because like the hearing that resulted in this judgment occurred after he retired.
Okay.
I don't know whether that matters or not. I think technically it might, but maybe it doesn't.
And you had a lawyer, I'm assuming?
I didn't.
Okay. And what's the nature of the lawsuit?
So I was suing the... what happened was in 2013 of April, I was assaulted outside my building by people who I knew... Like, I didn't know who exactly assaulted me, but I know who conspired the assault.
Oh.
And the police knew exactly who conspired the assault as well, and they... I have tons of evidence that shows that the police covered it up.
Okay.
So basically I was suing the two people who conspired to have me assaulted.
Okay.
So they were like neighbors who lived in the building that I used to live in.
A former resident.
That's right. Former residents of the former building that I used to live in.
Yes.
So they conspired to have me assaulted because I was making noise complaints against them, and that was going on for
and you advised this to the police service?
That's right.
They were fully aware of that?
Yes, that's right. And so...
Go ahead. I'm just going to grab a pad here, paper. Okay.
Sure.
Okay.
So, so the thing is that... So they obviously they know who assaulted me, and they conspired it, and they are known to me and to the police.
Okay.
And so I sued those two people. They were a father who owned the property above mine, and his daughter. So they were defendants in the lawsuit. Do you want me to name them or anything?
No. I'm just going to kind of trace sort of where ultimately the path of field law's judgment. Okay. So it started out as a lawsuit you had against.
So it was against 13, including. So field law was just the chief of police.
Yeah.
And then another lawyer, Wakowicz and Company, was representing the two defendants who conspired to have me assaulted. And
I see.
Yeah.
Okay. So Wakowicz, on behalf of, I guess
the Keefes. You can just two defendants. Their last name is Keefe, Keefe. Just to, I guess it's good to,
Yeah. And these were the two defendants that you're alleging conspired.
Right.
To. Okay.
And so then also, so there were 7 other EPS defendants who had differing levels of involvement in the cover-up and the investigation of the assault. So the chief of police is vicariously liable for all of EPS members.
That's why he was named in his personal
yes, exactly.
capacity. Okay.
That's right.
And then so the other, so Wakowicz, and then you've listed here Weir, Bowen, Dean Duckett, Carlson.
Right. So Weir Bowen is a separate. It's not Weir Bowen, Dean Duckett, Carlson. It's just Weir Bowen.
Yes, that's what I mean. Yeah, Weir Bowen and Dean Duckett, Carlson.
Right, exactly. Right.
So who did Weir Bowen?
So Weir Bowen represented the 7 other EPS members.
Okay.
And so like I said, they had varying degrees of involvement. And then the other one was Dean Duckett Carlson, and and the lawyer of their firm represented. Like I also sued the property manager of my building and the condo board and the property management company because they were, to varying degrees, like I say, involved in covering up the crime.
So Dean Duckett represented the property management / condo board?
Yeah,
okay.
that's right.
Okay.
And so, I mean, obviously because I was self-represented, it's difficult for me to, I mean, like, you might say, well, why did I involve so many people? And it's like, just because I expected to be able to question all of them. And that's why I named them, basically. So, I mean, you might say, well, why did I name, like the condo board? What did they really have to do with it? And the answer is, like, they were working with the property manager. Like, I'm. Yeah, you want to fast forward a bit, right?
Well, because what I want to lead up to is because I'm not here to obviously litigate or adjudicate on anything that relates to that claim. So the matter went to court.
Yeah, that's right.
When was the court date, or was it several? Or?
It was November 22nd to 23rd of last year.
Okay. Okay, November 2018.
And like I say, it was a summary judgment, so it didn't go to trial.
Okay.
And so this amount is what the judge called costs. So in other words, it's not penalties or fines, which I understand are not necessarily dischargeable.
Right.
So it's not penalties or fines. It's
so
just costs.
These are costs. And you have a copy of the order?
Yes, I do.
Okay.
You want it?
Okay.
I mean, yes.
So these are costs for each one of these representatives.
Well, the thing is that, so the judge decided to give them $20,000 each, and it's, I mean, for all intents and purposes, that's an arbitrary amount because, like, according to the rules of court, there's a schedule that dictates what they're supposed to be given in costs for a summary judgment application, and this is far beyond what they should have been awarded. Like, it's an extreme.
He just allocated, or she just allocated $20,000 across the board to each party.
To each of the four groups.
I see. Okay.
Right? So in other words, but this is an arbitrary amount. Like, you won't find an explanation for how this number was derived.
That's what the judge came up with.
Yeah, that's right.
Yes.
And, well, I mean, I'll say...
Plus, I'm assuming they've tacked on judgment interest and...
Well, it doesn't say that, but
no? Okay.
It might be. I mean, it doesn't even say plus GST or anything.
Because where did this is a precise number, 91.
Right, exactly. So in addition to this $20,000 each, and bear in mind, well, I mean, not bear in mind, but this order was written by Jeremy Taylor, one of the lawyers. So he wrote it, the judge, not even himself, but somebody on behalf of the judge signed it. So what I'm saying is that these numbers are in the judgment, and also the judge did pronounce that each of these defendants also got another $1,000 for a previous application.
I see. Okay.
So that's where there's 94 there, or 84 there.
Got it. That's where you get your
84.
Okay.
But there's also, like, last May, there was I made a couple of applications related to this, and so there's also these 3 bills of costs that were assessed last May, a year ago.
Okay.
So these were assessed on May 9th. So these are $2,625 each. So that's where I got this number. So this number is the 80,000 plus the 4,000 plus these 3 amounts, $2,625.
I see. Okay.
And so and so that's the thing. And so I haven't paid any of these.
Okay.
So.
Now, do you have, and I'm sure we can go through it as well, but just a breakdown of that $91,875 allocated to each party, because they are, hang on here, those amounts are payable directly to, were you required to pay those into court, or for distribution, or directly to the parties?
Well, to their, I mean
directly to the law firms.
To the law firms.
Okay,
that's right,
got it. Okay, so technically each Field Law Walk, and Dean Duckett are separate creditors. Okay.
That's right.
Okay. All right, and we can easily quantify, obviously, the 20 across the board, and then the additional amounts plus these additional amounts that came in. Okay.
Right, exactly.
And so, there was, and you were in court, but you were self-representing?
Yes.
Okay. And then there would have been a period of time, an appeal period, and was that, obviously something that you did or looked at? Was it something you were looking into? I think it's 10 days from the time.
Well, I think it's probably 30 days. I kind of gave up because this was a long, drawn-out process, and the judgment was so astoundingly unfair and unjustified that I just decided not. Well, I mean, I basically decided that I couldn't possibly appeal it without a lawyer, and I couldn't. Like, if I was going to appeal it, I would have to hire a lawyer, and I don't have the money to hire a lawyer, and I don't think I could really explain this to a lawyer, especially within a 30-day period. Like, it's extremely complicated, and that's, like the lawsuit was filed in 2015, so it was 3.5 years from the time I filed it.
Okay.
And at the time I filed it, the events were from 2013, so it was a long drawn out process.
Yeah.
And there's a lot of reasons why I don't even think it would be possible for me to appeal it, not because I was, not because it was the right decision, but because it was an unfair decision. Like, there's no way I could, I mean, the actual order itself, I could tell you how I could explain that the judge was in fact unfairly, biased against me. So in other words, I don't believe I could appeal it. Even like I think that that it would be just impossible to do. So in other words, I guess to make a long story short, I didn't appeal it.
Yeah. Okay.
And I think it's probably expired, the point of
Well,
appealing?
I know an idea with a different Court of Queen's Bench. I know that the appeal period with an order is 10 days from the time it's granted, and you'd have to, within the 10 days, show in appealing that the judge or the registrar erred in law. So now this was granted. How long ago was the original judgment?
So on this was from May of last year.
Yeah. Oh, okay. Well, the May of last year. Okay.
Right. So on that point, I did appeal these ones, but that was dismissed, I guess you could say.
Okay.
So I did try to appeal. Well, I did appeal these, in fact.
Yes.
But I didn't appeal the judgment from November.
Got it. Okay. And so we've got those judgments. Then I see a couple of Scotia visas, the overdraft, and the mortgage, which I'm assuming is in good standing.
That's right.
Your intention is to continue on and not to,
Yes.
sometimes people make the decision to walk away or surrender their property. If the situation is that, yes, it's your wish to continue to maintain the property, then you can. Whether it's and I'm going to talk about the two formal options available. One is the better known but lesser desired bankruptcy process, and the alternative, which we'll explore, is the consumer proposal. So it sounds like you've done a little bit of research, so I don't know if you've delved into a proposal process online.
I haven't. I mean, I guess I've probably briefly looked at it, but I don't think it's really applicable simply because of the amount of debt. I mean, there's no way.
Yeah, and again, it would definitely be low cents on the dollar. I mean, usually proposals are fairly low, but you're right. It's got to be realistic and viable, based on the current cash flow situation. Now, right now, you're not employed.
That's right.
And so how do you support your living expenses, your mortgage? How is that funded?
Well, I have cashed out, most of my RRSP. That's why it's down to $5,000. And periodically over the last year, my mother has given me some money.
So you've received some
but
assistance.
So and so going forward, I'm going to be cashing out more of my RRSP. I just I'm just very good with money. Like, I don't spend very much.
Okay.
That 5,000 I expect to last 3 or 4 months.
Okay.
And then after that, I'll probably look for a job, I think.
Okay. And your occupation as a software developer, and so are there prospects right now, based on what you're seeing, if you've been applying for positions? I don't know if there are any in Edmonton that you think are good opportunities, anything to that effect, or have you not looked at sort of that area as far as future?
I haven't really looked right now.
Okay.
I think that at this point I would probably need to go back to school to upgrade my skills.
Okay.
Just because it's been quite
a while. Okay. Yeah.
So I would have to go to school first.
Okay. And when was the last time you were employed? How long ago?
9.5 years.
Okay.
And so, I just was living off my RRSP, and I've just been very frugal.
Okay.
So, that's just it.
Okay. And so are there challenges to working on a full-time basis, whether it's health-related, or was it really just your intention to live off of your savings or RSPs? That's a personal choice versus roadblocks to actually being fully employed. Well,
I mean, what happened was that, so the last time I was working was in November of 2009, and then after I left that employment, I wanted to work on my own software development.
Okay.
So I worked on a project for a couple of years.
Okay, yeah.
Because I wanted to eventually, sell that product, and I wanted to develop it, and I wanted to take some time to make sure that I did that, myself.
Right.
And then in 2013, this assault happened, and for that 5.5 years, I've been going after the police.
So this is really consumed.
Yes, exactly. This has consumed my time, and that's it's just been an all-consuming thing. Is pursuing justice for 5.5 years.
Okay.
And like I say, I have so much evidence of police corruption that you couldn't possibly imagine, and it's something where everything that I know, most of it anyway, like everything significant that I can say is police corruption is documented. So in other words, I can publish all this to the internet and people will be shocked by what I know and what has happened.
And so with the RSPs here, they're now sitting at about 5,100 balance.
Right.
So at some point, and you've acknowledged it, right? I mean, that's going to be after the applicable taxes. It's going to run out.
Yeah, that's true. Yeah.
And so at that point,
then I'll,
there's really no other choice but to try to find a source of income.
Yeah, that's right.
Yeah, okay.
So now, and then it's one thing that I've been trying to contemplate exactly the technical aspects of how that will work because you see that RRSP account is with Scotiabank.
Yeah.
So currently, right, I have an online account which you see there, which has my credit cards and my basic banking account, and the RSP, as you see there, is I access it online, right? So obviously what I understand happens is that the bank closes my accounts, like they will close the credit card and the basic banking account.
They'll close the checking savings account where the overdraft, they'll obviously close the Visa account.
Right. And so, but they're not going to close the RSP account. But the thing is that currently I access that online through that website. So the thing is, I don't even know I don't know whether I will still have access to that website to access that account.
Right.
So now I was thinking that I will have to open another bank account at a different bank, right? So I was thinking that I could open a bank account and ask them to have Scotiabank transfer that 5,000 that are RSP over, right?
Yep.
Like as an actual thing, like not cash it out, but transfer it
into
as
another
is.
RSP account.
Right.
Yeah. So that's the key thing.
Or into it could be the same RSP account, but just accessible through that other bank's website. I don't know how that works.
Right. So the key thing, especially if now the consideration here is bankruptcy, which appears to be the only option, Greg, at this point to get the debts written off and settled. But with respect to the RSP, the rule with that is if you're going to close out our RSP account, roll it into another RSP, a very similar type of account, making sure it's under that RSP umbrella with a different bank. That's fine. That's fine because of access issues. Right.
And that is the thing, the access issue. So in other words, I don't want it to. I'm not planning on cashing it all out at once. I'm going to cash it out gradually. But the thing is. And, probably in the next month or so, or the next few weeks, I'll have to cash out 1,000 or something from it. But the question is, so I'd like to transfer it as is, untouched and unblemished, right? Just as is. I don't even know, if I'd like to ask the new bank, can you contact Scotiabank and have them transfer it over, right? And so the thing is, without affecting its status, it's made up of 10 different mutual funds, I guess. I might as well just say that. That's what it is. It's just 10 different mutual funds. And those are, I believe, those are all basic Scotia Bank mutual funds.
So they'd have to find something that's very obviously quite similar if you're looking at the same allocation and investments.
Right.
But that's a question for the bank. So whichever bank you decide to open with, that's a question for them. Okay, is to find, because I don't know, every bank is different, whether they can actually go in and do the transfer. Of course, they're going to want to know, which accounts do you want these funds allocated to? So
they won't be the same funds? They'll be different ones?
They'll be different, I'm assuming. Because, again, I don't know what investments this is comprised of. Right. Is it a Scotia, money market account? Is it a Scotia GIC? I don't know. So,
I mean, if you want, I could log in and show you.
It won't matter to me, though, because that's a function of the banks, okay? So when you contact the bank, and the new bank that you intend to open with, ask that question. Is Because the choices are, you keep it intact with Scotia, but of course the issue there is access.
Yes, exactly.
So if your intention is to move it out, and so you could access it with a new bank, find out from them what are the mechanics of that. What is it going to take, and how is that going to impact the investment allocations that's currently in there. And they'd probably bring with you, a current or the last statement or log in and show them the distribution so that they can sort of do a comparison of what they have available.
Right.
Okay. So, the key thing from our perspective is, yes, moving your funds out of a Scotia bank account because of once we send notice to the creditors in a bankruptcy, and with Scotia Visa in the overdraft as debts, you don't want exposure to any funds you deposit into a checking or savings account. So definitely opening up a new bank account. But those very specific questions about transferring your RSP, I don't have the answers for that. That's very specific to the bank you're going to be dealing with.
Right.
Okay.
So the other question was, like, when I contact the new bank and I ask them, could you transfer this Scotia, so I'll contact the new bank and I'll say, I have an RRSP account with Scotiabank and I'd like you to transfer it to your bank. So how do I approach that question with the new bank? Like, do I have to tell them that I'm doing bankruptcy? Or
No, not at all.
I mean, aren't they going to ask, why are you doing this? Like, they're
it's
going
his
to
preference. I mean, a common response to that would be, well, I prefer to move all of my banking as well as investments into one bank. I mean, that's it. There's no requirement or to disclose your intention to proceed with a bankruptcy. Not at all.
But they're not going to ask why. They
possibly could. Possibly could.
Can I actually tell them I'm not going to tell you? Because obviously that's going to raise a red flag.
It's completely up to you.
Well, I mean, because they'll want to know, why are you doing this? Like, why are you taking your RSP from Scotiabank and moving it to us? Like, with nothing else. Like, I'm not going to give the new bank money until I start cashing out that RSP, which of course will be shortly.
Right.
It'll be within a month at the most. I'll be cashing part of it out. But the thing is, the bank is going to wonder, why are you taking an RRSP from an established bank, that you've had business dealings with. I don't have to tell them how long I've had business dealings with Scotiabank, but it's been over 30 years. So why are you taking that out from there and giving it to us? Like, why would you be doing that?
Well, like I said, a response could be that you prefer to have all of your banking investments included under, one bank. I mean, that's one. Or you advise them exactly the reason why.
Like, tell them that I'm filing for bankruptcy and that I want to...
Or you can advise them that you're doing a financial restructuring. You don't necessarily have to tell them that you're doing a formal bankruptcy. A financial restructuring that's going to require you to move all of your investments. I mean, and really, I'd be surprised if they would really delve into the why, because really, it's a personal choice.
Well, I guess the thing, I mean, I personally wouldn't be surprised if they, if they go into some degree of questioning, because it is kind of a peculiar, request. Like, I mean, in terms of moving.
Not in my world though, Greg. I mean, oftentimes people.
I guess
we instruct people to switch their banking. It's a requirement, and oftentimes this comes up. Well, what about my GIC? What about my money market accounts? What about this? And can I move it to the new bank? It's absolutely up to you to do that, or you can stay put. But I understand why you want to do
access.
that. Exactly.
I mean, that is the reason.
And it's yes. I mean, I think it's reasonable to suggest that yes, the banks will probably ask why. But with that, I don't think it requires a deep response. A really detailed response to them. I think they're just going to want to know at a very high level.
Well, and the thing is too. And I mean, see, obviously, the one of the problems with this situation is I have no idea how anyone's going to respond to any of this, right? So in other words, I don't know. Like, Scotiabank may say, well, we can keep giving you access to the RRSP account. I doubt it, but in theory, you'd think that they would just close the other accounts and let me still have access to that account online.
You would well, and again, you would still have access to the RSP account, whether it's online through the, your online banking,
Right.
because that's tied to the bank account.
Yeah.
Probably not, but
Okay. Yeah,
but there are
that's the thing.
1-800 numbers, right, that you can call directly
Mhm.
if you want to redeem in RSP. You could that is set up as well
Right.
for people who don't have computers. So I think. But if it's the access that, the mechanism for accessing that you prefer online, well then, yeah, chances are they're going to
Close it all down and
so.
just block my access to
Yeah.
that account altogether.
Yeah. Yes.
And the thing is too that when you call them online to do like cashing out and
Mhm.
switches and stuff like that,
Mhm.
they do charge you for using them online on the phone. Like if you do that on the phone as opposed to online, they do charge a service fee.
Oh, do they?
Yeah, for doing it on the phone.
Oh,
Just because
okay.
you're talking to a person, and if you don't do it yourself, they charge you, I think, $25 at least,
Okay.
just to do it on the phone.
Hmm.
So
Okay.
that's why, obviously, I'd rather
Yeah.
avoid that.
Sure,
But
sure.
but the thing is too that if I go to a new bank, are they going to put it against me if I tell them that I'm filing for bankruptcy? Like, in other words, is that a negative thing? Like, I think it is. I think if I phoned a bank and said, I'm transferring this over to you because I'm filing for bankruptcy and my current bank is going to close my accounts, they're going to say, well, we don't want to have anything to do with you.
My response to that is it shouldn't be, but sometimes it is because of the misconceptions about bankruptcy.
Well, because it's
and that's why that's why we, number one, get people to open up a new bank account before they proceed with a bankruptcy, because it is going to be more difficult post-bankruptcy filing to do that. But again, as far as the discussion, if they ask why, is, stick to the financial restructuring part. I'm restructuring my finances. They don't need to know that you're proceeding with a bankruptcy.
Okay.
Okay?
Because financial restructuring isn't...
That could be informal. That could be just you informally, reworking your finances.
Okay.
Okay? That's quite a general. That's quite a general.
And that's the thing, is you don't think that they'll be digging into that question.
Greg, like I said, we give this as a requirement to anybody who files a proposal or bankruptcy, and there have been no issues from people. Okay. So I don't think you're going to find it that difficult.
Yeah. And that's just like, I always worry about what questions are going to be asked, because it seems it's exceptional. Like, it's not typical to move just an RSP account.
And by law, I think if you go into the consumer advocacy sort of website for Alberta, they can't deny you a bank account by virtue of bankruptcy. Okay?
Oh, really?
They cannot deny you a bank account.
Okay,
it's not an extension of credit, number one. Okay? It's opening up a deposit account. You don't even need to have money to put in that bank account.
Oh.
It's your right, as long as you have proper ID,
and
show that you have a residential address. You have that right to. But go into the, if you wanted to read about it, the Alberta government, sort of knowing your rights as a consumer.
Yeah.
I can't remember the name of the website. But take a look at that.
Okay. That's interesting, because I thought that you actually had to put money into an account.
No, that's a common misconception. It's not. No.
Because I always thought even that you'd actually have to have a job to open a bank account.
No. You
can
need
just
your
open
photo
up
ID. You need something that shows you're at a permanent address.
Okay. Yeah, and obviously, and I mean, see, the easiest solution, I mean, if I, just to be totally frank, I suppose, the easiest solution would be to open a bank account at the same bank that I have my mortgage with.
Okay.
Except, and that is, I mean, that's a concept,
ATB.
That's an option, ATB, right? They have my mortgage. So, like, I've set it up, I don't know, and maybe it's unusual to have two different banks where I have, like, my everything else at Scotiabank and the mortgage was at ATB. And I think the only reason why I did that was because ATB had a low rate at the time, and that's why I chose them for the mortgage.
Right.
So I was thinking I could set up a bank account with ATB and transfer the RSP over there, and then everything would be all together. But the thing is, well, I don't know. I kind of like having them separate anyway.
Okay. Well, and that's a personal decision.
Yeah.
So
I'm glad
we'll
to
get
know
you to as one of the to-do list items is opening that bank account. Are any of these debts joint with any other party?
No, they are not.
Okay.
No.
Okay. Now, with respect to the mortgage, and the condo with the stalls, the $203,500. Where does that value come from?
So that was just from that value
is that
is
the
from
property
the
tax?
Yes, exactly. That's what that is, and I can just show you that.
Yeah.
So that, and so they, I think it was just last week they sent out the property tax notice.
Is that 2019?
Yes.
Okay. I'm just going to run online comparables because usually with the city's assessment that's outdated.
Yes.
And we always go by a realtor opinion just because the market changes all the time. So let me just bring it up here.
And I kind of expect that the property value is probably less than it is on the notice, simply because the market. I've just heard.
Yeah. Yeah. And are there units selling right now
in my building?
Yeah, that's comparable to what to yours.
There's, I believe there are. I've seen signs on the front of the lawn.
Mm-hmm.
But I haven't looked into it, and I guess maybe I should have, but I just haven't looked into that, so I don't know really.
So what I'm pulling up here is it is an online. It's almost like a broker comparable, a database, and it's going to pull up sales comps for the last 6 months based on that municipal address. Okay, so I'm just going to plug it in because I'm curious to see how close it is to what the city assesses it at.
Right.
Okay, so I'm just going to plug in the municipal address. So let's just see what it says. Okay, so that is
So that's that building, eh?
Yeah, so I'll just turn my monitor here for you to see that. Okay, so that looks like it.
That is it.
Okay, so let's just see here. Oh, pretty close. 2019, and what did you say the city? 203. Okay.
Including the parking spot.
Yeah, and that includes those. So that's probably pretty fair and reasonable then. Okay.
Okay. And
so they pull up comps. Now, again, this is again, we don't know if it may not be right in the building because it looks like they're different addresses, right? But occur around the area. Yeah. So okay, but again, looking at about 2019, but we'll go by the city's assessment because that includes the stalls.
Right, exactly.
Okay. And so the property itself, because the equity is less than $40,000, that's the allowable exemption when it comes to your principal residence for bankruptcy.
Right.
Because the equity, after I factor out selling costs, hypothetical selling costs, your equity will be less than $40,000, which means it's an exempted asset. So essentially, you just continue to pay it as normal. Okay. So what I'd like to do is just take a copy of this.
Sure. And so this is the
latest one.
Right. So this is just the condo, and because the parking spots are titled, they are separate tax bills.
Oh, okay. Can I take a look at it though? So this wouldn't state what the parking stalls are.
That's right. Yep. The parking stalls are separate.
Okay. Yeah. So I'll put that together and just do a quick scan.
Yeah. So these separated.
And you have 2 parking stalls?
Yes.
Okay.
But I don't have a car, so.
Oh.
The property just happened to come with it when I bought it.
Okay. Oh, it just did come with it. Okay.
Yeah, it just came with 2 parking spots, and I just I haven't had a car in many years. I just walk everywhere, so.
Yeah. Okay. That's a good cost savings there, though, too. You don't have to worry about insurance.
Right.
Okay. So this is based on property tax.
And I was, the thing is that I was thinking about renting the parking spots, but it doesn't look like I've never seen the parking lot of my building being full, so I don't think there's a demand for parking spots. I don't know why that is, because it's really, when I lived in my other building, I first rented and then I sold my parking spot, which was a big mistake because it made it extremely difficult to sell my property.
Okay, yeah.
But in my other building, it was an underground parking spot, so there was like that.
Back again and just rescan them. Okay, so they're there, but you're not paying sort of extra for these, like a monthly for the actual stall.
I'm not paying for them. Like the only thing I pay for them is the tax.
Is the tax, okay.
So, like on the question of the equity, I kind of have come to understand that because the equity is less than 40,000 and that's exempt, it's very unlikely that these creditors who have these writ of enforcements, like they have the creditor statement of debtors' land, so they have an interest in the property. I don't know if I got to that point yet. But
no, so they have registered their interest.
Well,
okay.
So this is the chief of police, former chief of police. He's registered an interest in the property.
Yep.
And then 3 of the other defendants have, but not the other.
Right.
Which is kind of peculiar. Like, I don't know. I mean, maybe they just decided that there is no point because spreading it out among all of them would be, they're not going to get anything out of it.
Okay. So so this is quite common. It's a common next step for judgment creditors is they just, if they go to land titles, run a land title search, he's got property, slap that writ on there. So what would happen is, with the bankruptcy, once you receive the discharge, so that's really the goal is to get the discharge because this is what will legally release you from the debt.
Right.
Once you get the effective discharge, you can then go to land titles, provide land titles with a copy of your discharge document and proof that these creditors were included in the bankruptcy, okay?
Right.
And they will remove the writ.
Right.
Okay? So, but this is quite common. I mean, they basically will just stay on there until you sell the property, but by virtue of the bankruptcy, that will sort of, what that in effect will do is just sort of wipe out that writ.
Right,
okay?
Exactly.
Okay.
And the thing is that, so like I say, so that the chief of police has this, and then 3 of the other defendants, but not the other, 9 defendants. So in other words, but they're still creditors, right?
Yep.
Even though they don't have a writ of
enforcement. No. Yeah, they're still creditors. Well,
right.
Yeah, absolutely.
So
it's just that they're a little slow on the go.
Yeah, they just haven't gone to the step.
Exactly.
So the thing,
so let me just quickly go through the process, okay? So, because it's important for you to fully understand what's involved. So, what happens immediately upon filing the bankruptcy is what is triggered is what's called a stay of proceedings. What the stay does is it automatically freezes all creditor collection action.
Right.
So, and they understand that. So, basically, their collection action stops. They're basically put on hold, and the debt is wiped out once you receive the official discharge. When that happens is either 9 months or 21 months if you've never filed a bankruptcy before, and I see you have never.
That's right.
So we can eliminate these longer timelines. So as a first-time filing, the best case scenario is you would be receiving the discharge 9 months from the day you file.
Right.
Okay, not any sooner than that, legislatively. It could turn to 21 months. However, your net income sources has to go over 2,203 net.
Right.
Okay, that's that magic number. That's that threshold that if it goes over that on average, then you're looking at 21 months.
Right.
Okay, and your monthly payment, if it's a 21 months, is 50% of the surplus over and above this. So if you go over by 600, your payment's 300. Okay?
Right.
But this, as of today's date, does not apply, and therefore we're saying, look, you're eligible to receive the discharge in 9 months. The minimum fee for a first-time filing is $1,800, which is payable at either $225 per month for 8 months or $100 a month for 18 months. Okay, so that essentially will replace the payments you would otherwise be paying to the unsecured creditors.
Right.
Okay. The duties are really straightforward. There are 2 mandatory financial counseling sessions, so it's just twice you would need to attend our office. Getting us your tax information. So we're legally required to file your 2019 taxation, which isn't due until April 30th next year. The end result of this is you would lose any tax refund. So that is redirected by CRA to our office as an asset for the creditors. Okay? And then 2020 and beyond, it reverts back to you. Okay?
Any tax refunds?
Refunds, yes, that's right.
Are going to the creditors.
You would lose that, yes. That would become, if the bankruptcy is filed in 2019, then any 2019 tax refund you would lose. Exactly. It becomes an asset. Okay? Filing your monthly income and expenses. Now, we won't have you do this because you don't have a consistent income. However, instead, we will just have you prove to us when you come in for the 2 counseling sessions that your income situation has not changed. So it's just showing a bank statement to show, okay, no, I haven't received any income.
Right.
As long as you meet those duties, and as long as no creditor objects, and I'll talk about that shortly, you get an automatic discharge 9 months without court involvement. The only time the courts, which are the bankruptcy courts, the only time they are involved is if there is an objection filed. And it can come from one of 3 places. So I'll talk about creditor objections. So creditors do have rights in this process. They do have rights to object to the discharge, but they need really strong grounds, okay? Strong grounds would be in the realm of fraud. You know, there was fraud committed. There was a misconduct in the way you incurred the debt. If you would, use a significant amount of credit on the eve of filing the bankruptcy. I'll just give you an example. I had a gentleman who, he had a CIBC visa at $20,000, and CIBC objected to his discharge on the basis that, according to their statements of account that they clearly could see, he took a trip to Mexico, I think, 30 days before filing, knowing he had intended on turning in the cards. So that it was blatantly obvious, okay? So again, if the creditors object, then they'll be notifying you, they'll be notifying us, and the matter is decided by the bankruptcy courts. And they, again, would need to compel and satisfy the courts that there's a really substantial reason why that debt should survive the bankruptcy. Okay, Now this is costs. Now clearly these are judgment creditors. These are costs, and once they see the statement of affairs, they're going to see that you have no financial ability to pay it. Okay. The second place the objection can come from is from us as trustee. We're legally obligated to object, but that's only if you don't complete the duties. So if we never hear from you after you sign the paperwork, you don't attend the counseling, you don't provide us with tax info, these are really straightforward duties. Okay? An objection by the official receiver. They are the regulators of the process. Again, very similar to the grounds for the creditors, okay? If there was a strong misconduct, okay, in how the debt was incurred. Okay? Right. Otherwise, your target should be 9 months, and you should be focusing on completing the duties in order to get an automatic discharge.
Right.
There are debts that survive bankruptcy in Canada if you owe child or spousal support, not the case here. Court-imposed fines. So these are fines in the sense of like highway traffic tickets, photo radar, restitution orders, okay? Debts that arise from fraud, embezzlement, or misrepresentation. Again, I don't see that in these debts. Student loans under 7 years or civil assault claims that you've made, okay? So these debts survive in Canada.
And civil assault claims, that means that if I assaulted
If you assaulted somebody, they sued you.
Right.
Yeah, that's different. Okay.
So now, I'll tell you that, and this is one of those things, and this, I'm quite sure, if you read this order, you won't see anything that refers to what I'm going to tell you, but, like I was saying, the defendants filed summary judgment applications, and they filed those in, December and November of 2017, so a year before the judgment was made, right?
Right.
So they filed those summary judgment applications, in 2017, late 2017, to be precise, October and then November and then December. So now, 3 weeks before, so this trial, this hearing, which was 2 days, November 22nd and 23rd, was scheduled in June of 2018.
Okay.
So it was all
there was
set
a
to
trial
go.
scheduled?
Well, it's not a trial exactly. I'll use the word trial loosely. I guess I shouldn't use
You
the
mean
word
an
trial because
examination?
it was just a hearing. It wasn't. There was
Okay.
there was no cross-examination or anything.
Yeah.
So I shouldn't use the word trial because it wasn't.
Okay.
I think somewhere somebody called it a mini trial, but it wasn't really because there was no witnesses and there was
not in the true sense
yes,
of the
exactly.
word.
So it didn't go to trial. So I shouldn't use the word trial. But so it was because basically, to be very specific, when you do a summary judgment application. It would usually go before a master of the court, but if the master cannot determine the result in like the 20 minutes allowed, then they say, well, we'll make this a special application.
Right.
And then they schedule it like months down the road because the courts are very full and everything.
Right.
So in June, this was scheduled to be heard. Those 3 summary judgment applications. So 3 weeks before that was scheduled to be heard, Jeremy Taylor, the